Hello and welcome to this FedSoc Forum webinar call. Today, June 27th, 2024, we're delighted to host a discussion on the law, policy, and politics of rescheduling cannabis. My name is Kayla Kleiss, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, we'll keep our introduction of our guest today brief, but if you'd like to know more, you can access any of their impressive full bios at fedsoc.org. Today, we are fortunate to have with us as our moderator, Paul Larkin, who is a Senior Legal Research Fellow with the Center for Legal and Judicial Studies at the Heritage Foundation. Before joining Heritage in September 2011, Mr. Larkin held various positions with the federal government in Washington, D.C., including at USDOJ from 1984 to 1993, where he served as assistant to the Solicitor General and as an attorney in the Criminal Division section on organized crime and racketeering. From 1996 to 1997, Mr. Larkin served as counsel to the Senate Judiciary Committee and as head of the crime unit for Senator Orrin Hatch, who was then the panel's chairman. He also worked in the Environmental Protection Agency as a special agent for criminal enforcement, serving as acting director in 2004. In the private sector, he worked at two top law firms in Washington, D.C., and as assistant general counsel for Verizon Communications from 2004 to 2009. I'll leave it to him to introduce our panel. A last note, and then I'll get off your screens. If you have any questions, please do submit those via the Q&A feature found at the bottom of your Zoom screen, so it'll be accessible when we get to that portion of today's webinar. With that, thank you all for joining us today. Mr. Larkin, the floor is yours.
Thank you very much. I appreciate it. Let me say to everyone who's tuned in or who watches it later, thank you. We appreciate you taking time out of your day to listen to the two experts that we have here. And these are terrific experts, okay? They're going to talk about the subject of rescheduling of cannabis. It's a controversial subject and has been that way for more than 50 years. Since 1996, numerous states have legalized the use of cannabis under state law for medical or recreational purposes. The federal act governing this subject, at least the principal one, is the Controlled Substances Act of 1970. It outlaws the cultivation and distribution of cannabis by placing it in Schedule I, the category for drugs that have no legitimate medical use. Despite the state's recent cannabis legalization efforts, Congress has never revisited the law in this area. Cannabis, therefore, remains contraband under federal law. The Attorney General of the United States has always had the authority to reschedule cannabis, but none of them in either party has ever exercised that authority. In 2022, President Joe Biden directed U.S. Attorney General Merrick Garland to reconsider the classification of cannabis. This year, Garland recently announced that he would move cannabis from Schedule I to Schedule III, which would enable physicians to prescribe its use. Today, as I said, we will hear from two nationally recognized experts on the subject. Going first will be Professor Doug Berman. He is the Newton D. Baker and Hostetler Chair in Law and Executive Director of the Drug Enforcement and Policy Center that is housed in the Moritz College of Law at the Ohio State Law School. A graduate of Princeton University and Harvard Law School, Professor Berman was an editor of the Law Review there. And in keeping with that interest, he founded the Moritz College of Law Ohio State Journal of Criminal Law. He is the author of two case books, one on sentencing, which is one of his passions, and the other entitled Marijuana Law and Policy. He has authored more than 100 articles and other publications in law journals and other sources, and he edits the Marijuana Law, Policy, and Reform blog. Batting second will be Professor Bertha Madras. She is a professor of psychobiology at the Harvard Medical School. She is based in McLean Hospital and is cross-appointed at Massachusetts General Hospital. Her research has focused on, among other things, neurobiology, addiction, and public policy. Among other positions she has held, and there have been many, she has been the Deputy Director for Demand Reduction in the White House Office of National Drug Control Policy, and later served on President Trump's Commission on Combating Drug Addiction and the Opioid Crisis. She also was an expert witness for the U.S. Department of Justice in a 2015 case where this federal government decided to maintain the Schedule I classification of cannabis. She has published more than 200 scientific manuscripts, articles, book chapters, and the like, and has also co-authored the book Cell Biology of Addiction. With that, we'll go to our leadoff batter. Professor Berman, dig in.
Thank you very much, Paul. And my understanding is I'm going to talk a little bit about the decision to reschedule, or the effort to reschedule, ongoing. And I'm incredibly grateful and thankful to my fellow participant, and to you for moderating, and to the Federalist Society for having us here today. I'm tempted, particularly because it's the Federalist Society that is sponsoring this conversation, to say we are all originalists now, and so we need to start with a little bit of history. And that history is the anthropological and archaeological evidence that cannabis has been used as a medicine for thousands of years. In fact, it's been used as a medicine in the United States for most of our history. It was only in 1942 that it was removed from the US Pharmacopoeia. I bring this up because a key factor under the text of the Controlled Substances Act for scheduling of drugs is whether or not a drug has any currently accepted medical use in treatment. And so that's often a key factor. I suspect we'll talk more and more about this part of HHS's decision to recommend rescheduling. But if you look at most of world history, most of US history, the answer has been yes, that there has been accepted medical use in treatment for the cannabis plant, the marijuana plant that we're talking about. We could do another version of history that I think is relevant and important here, which is the history around Congress's creation of the Controlled Substances Act in 1970, when marijuana was initially placed in Schedule I. My understanding is that was done provisionally with recommendations that were built around the idea that there needed to be more science to really understand where marijuana would be properly placed. Part of that period included then President Richard Nixon convening a commission, the National Commission on Marijuana and Drug Abuse, that was colloquially known as the Schaefer Commission after the head. And at least as I understand the reporting at the time, that President Nixon made sure that there were not a lot of cannabis fans, marijuana fans on that commission. Nevertheless, that commission came back after a year or so of study recommending decriminalization of personal possession and use, based largely on the conclusion that there was little proven danger of harm for most marijuana users. They didn't recommend legalization. They didn't recommend where we're headed as a nation right now, but they emphasized their conclusion that for most marijuana user, there was little or no harm. Why do I bring that up? Because again, the text of the Controlled Substances Act asks, when deciding about scheduling of a drug, whether a drug or other substance has a, quote, high potential for abuse, and whether there's a lack of accepted safety for use of the drug or other substance under medical supervision. All of that adds up to the reality that Schedule I drugs, the language, the text of the Controlled Substances Act for placing drugs or other substances in Schedule I basically says it's the very most dangerous of drugs that should go in Schedule I. Marijuana was placed there not based on science, but with an expectation that science would be conducted to figure out where it should be placed. And ultimately, through a variety of political, social, and scientific realities, it would stay there for the better part of 50 years until we've now gotten this recommendation from Health and Human Services that concluded that that's the wrong classification. And HHS specifically focused on evidence that exists both in literature and in public use that therapeutic cannabis could be used for treating anorexia, nausea, vomiting, pain. Also, they reference, though, the literature, as I understand it, and the doctor could give us a lot more, I'm sure, about using cannabis to treat anxiety, epilepsy, PTSD, inflammatory bowel disease. All of those particulars can and should be unpacked by scientists. I'm not a scientist. I am a lawyer. And as a lawyer and law professor, I read the text of the Controlled Substances Act and conclude it doesn't fit in Schedule I. What I also know, though, and I want to kind of close with this point, that I'm not sure marijuana described just with that label, or cannabis, the plant described scientifically, is rightly placed in any single schedule. Opioids, which rightly are a concern given high overdose rates and death that fentanyl particularly has led to, but that has long been a problem. Opioids appear in the schedules in all of them. There are certain versions of opioids that are Schedule I. There are certain versions of opioids that are Schedule II, III, IV, and V, all the way down, because depending on how the drug is composed, the dosage, the treatment context, and the like, it rightly or wrongly deserves to be in a different sort of schedule. And so my actually biggest concern is it's easy to say, at least from my perspective, that marijuana doesn't merit a place in Schedule 1. But I'm not sure where it merits a place, and I'm inclined to think, and I think the scientific literature that I read but don't produce suggests that high THC versions of cannabis are probably significantly more dangerous than low THC or even almost no THC versions of cannabis, and that those other versions of the marijuana plant maybe should be moved down the schedule in a variety of ways. High THC perhaps in Schedule 2. Lower THC in Schedule 3, maybe very low THC descheduled, which is where we've gotten to thanks to the Farm Bill with CBD, one of the chemicals in cannabis that may be the one that has the most medical applications. And so you put all that together, and like the nuanced law professor I aspire to be, I say part of the story is easy. This shouldn't be in Schedule 1, and that makes sense to me as a sensible recommendation for moving the law forward consistent with what Congress has put in the Controlled Substances Act. But exactly where cannabis should be located and how we should move forward with better policy, science-based policy under the Controlled Substances Act, that's even harder, and one that I'm eager to hear from the doctor and continue to talk about, because I don't think we've figured that out, and I don't find the decision to move the entire plant to Schedule 3 as itself completely supported by the scientific literature that I've been reading.
Professor Berman, thank you very much. Professor Madras, you're now at bat.
Thank you very much. I hope you can hear me.
Yes.
Excellent. So just before I go into my talking points, can I just spend about 30 seconds responding to some things that Professor Berman said? Marijuana was in the pharmacopoeia. It was removed. First, the British government removed it, and then the United States government removed it because they felt that the cost-benefit equation of using it as a medicine did not justify it being designated a medicine, particularly because of the adverse side effects, and also the fact that there were more drugs coming on the market that were far better and more effective than marijuana. So I think we have to, include that in the history. Secondly, it wasn't universally used as a medicine at all. China only used it as a medicine. India used it recreationally, and marijuana did not enter into European society or Britain until the mid-19th century. It was unknown. So I think one has to be very cautious. It certainly did not go into the Western Hemisphere until much later. Because its origins is actually in Central Asia, in what's now known as the stands. Thirdly, the concept of marijuana being the most dangerous category, the implication, according to the way it's been framed, is that it's not lethal like opioids are, and therefore things that are in Schedule 1 are essentially there because they are extremely dangerous in terms of lethality or other human consequences. But obviously hallucinogens, and many of them are not lethal either. They're still in Schedule 1, because Schedule 1 is essentially a two-pronged determination. One is abuse liability, which has nothing to do with death as an outcome. And secondly, medical use. And so we have to deal with the most important issue from my perspective is medical use. So I'm going to briefly make 5 points, and then we can expand on them during the Q&A because I've already chewed up too much of my time. HHS waived the DEA 5-part test and 8-factor analysis and FDA criteria in order to make this push to put marijuana into Schedule 3. And here is the 5-part test, which I think is really bears on this topic. The chemistry has to be known and reproducible. Marijuana, as it's sold in dispensaries and or retail outlets or homegrown, has no known chemistry. the chemistry is all over the place. There are over 100 cannabinoids, depending on how the product is formed in terms of concentrates and so on. The percent THC can range from 1% all the way to 99%. So the chemistry is not known. It's certainly not reproducible. There have to be adequate safety studies. There certainly have not been with regard to some of the medical applications, especially in chronic use. There has to be adequate and well-controlled studies proving efficacy. There are currently hundreds of meta-analyses. The most prominent medical application that is not only quoted and self-reported by users, but also by the National Academy report of 2017 is for pain. And currently there are approximately 24 meta-analyses that are recent with regard to pain, and Epistomonikos, which documents many of these meta-analyses and evidence for medical purposes. The conclusion of all of them is that there is no strong evidence for the use of marijuana for all forms of pain and for chronic use. So I think we have to disabuse ourselves of the medical applications that are listed. Now, why should it reside in Schedule 1? There's good evidence that individuals are taking the drug or drugs containing the substance in amounts sufficient to create a hazard to their health. The most recent publication on cannabis use disorder is that 25%, as high as 30%, who are taking it either for medical or for recreational purposes have a cannabis use disorder. There's also significant evidence for diversion of the drugs from medical applications to a recreational use. And that is evidenced by a recent published paper showing that about 79% of people using it for medical purposes also use the drug to get high. So individuals are taking the drug or drugs on their own rather than on the basis of strong medical advice from a practitioner. They're just given a card recommended to take it without any follow-up, without any assertion of whether or not they are becoming addicted, whether or not they need it for long-term use, and so on. It's simply an open-ended access to the drug as a medicine. So why should it not be in Schedule 3? The drug approval process previously was based on strong evidence for efficacy and safety, and not on popular opinion, not on ballot or legislative initiatives or what lobbying groups and individuals desire. Unfortunately, this is what's happened with regard to marijuana. It is simply the will of a public that has been very, very significantly indoctrinated into the concept that marijuana is a medicine and it is safe and it is non-addictive. So what is the current evidence for marijuana as a medicine? Is there a consensus that it belongs in Schedule 2 and below? Illinois has 40 chronic diseases and conditions: cancer, glaucoma, hepatitis C, Crohn's disease, Alzheimer's, cachexia, syringomyelema, rheumatoid arthritis, fibrous dysplasia. I can go on and on. I won't list all 40, but all of this is complete science fiction. There is simply no evidence for 99% of these medical indications. And these were made up in whole cloth in Illinois. Many of the indications, for example, in California, say AIDS wasting and nausea due to chemotherapy, but any other medical condition that is deemed for which it's deemed necessary, without evidence. So the current medical marijuana, this is my point number 2, it's a mess, and it'll become far messier than ever before because of the rescheduling. So we have 38 states that have approved of medical marijuana, and Puerto Rico, Guam, the U.S. Virgin Islands, and D.C., and 24 states have recreational marijuana. A Schedule III drug implies that there's safety concerns of abuse, liability, and health. Accordingly, Schedule III drugs require a prescription, cannot be sold over the counter. Yet marijuana is available as an over-the-counter drug for anyone in 24 states and DC. How will this impact adherence to Schedule III drugs for marijuana? Will physicians be able to prescribe marijuana in contrast to recommending it? For what medical condition? Where's the evidence for it? For what dose? For what frequency? For what route of administration? Gummy bears, vaping, colas, sodas, suppositories, hand creams, smoking. There's simply no science behind any of these routes of administration. There's no science behind doses that are up to 99% THC and a bolus of somewhere between 50 and 200 milligrams in a vaping pen. What about for what duration? What contraindications? Any age, pregnant women, children, the elderly, people with an underlying psychotic condition, with depression, suicidality. There is absolutely no firm commitment on the part of the FDA or HHS to offer and to generate packets that are essential when you go to a drugstore and get a prescribed medication, in terms of your dose, how frequently, what the side effects could be, and whether or not you are in a category of demographics that should never touch this stuff. Will insurance companies be compelled to reimburse when if there's no evidence? Will bud tenders with zero training be the ones who advise patients given a prescription on what to use? This strain, Hindu Kush or diesel fuel. These are the names that are currently designated even in medical dispensaries. And of course, have acceptable standards for efficacy and safety of marijuana as a medicine been met? Is there standardized doses? Right now, it's between 4% and 99%. How often should these doses be taken? What purity do they have? A recent study done in California showed that half of the substances purchased in dispensaries had pesticides, dangerous pesticides. What about different strains? What about the ratio of THC to other cannabinoids? And as I said,
Professor Madras?
Yes, sir. I have two more sentences.
All right, that's good.
The practice of medicine will be compromised because of this change. Anything goes will begin to dominate previous rigor in the standards. And how will physicians decide whether to prescribe? And the fifth point is the FDA's high bar for drug approval, developed since 1938 and imposed on our drug supply, will be damaged permanently, and so will the safety of our pharmaceuticals. Professor
Berman, would you like a couple of minutes to rebut?
Yeah, just a couple of minutes of response. First, and I don't want to misrepresent Dr. Madras's views, but it sounded like I heard there are some medical applications, but they're very, very limited, and the evidence in support of it is mixed in a variety of ways, whether it's pain, whether it's wasting disease, whether it's for terminal cancer patients, whatever the particulars are. The text of the Controlled Substances Act says you're only in Schedule I if there's no currently accepted medical use. It sounds as though there may be an array, again, lots of challenges in turning it into legitimate medicine. And I will be the first to say the way medical marijuana regimes unfolded, starting in California, was not the medical gold standard. It wasn't even the medical silver standard or bronze standard. It was not a standard at all. But that is a byproduct of the fact that the federal leadership here failed when it came to dealing with the AIDS epidemic and all the harms that resulted from that directly led to the medical marijuana movement, has failed cancer patients, That's why we're seeing, among other things, psychedelics, which you mentioned before, coming out of the Schedule I woodwork as well as we deal with the challenges to mental health, particularly for those dealing with terminal illnesses. The existing apparatus has had, and you mentioned the DEA standards, has had a bias against new innovations and new medicines that may be very safe as a general bias. Let's not try anything unless we have a decade of research showing it's safe for everyone. But President Trump signed into law the Right to Try Act, in part because that deserves at least some patients, often the most vulnerable and those most in desperate need of an innovation, even if it might prove to be a harmful innovation. It's that failure keeping marijuana on Schedule I when it just isn't supported by the text or the science that ultimately leads to this state innovation that has all sorts of harms and failures. And so for me, I'm hopeful, not optimistic, honestly, but hopeful that the federal government, being led by science, and I don't think Schedule III is scientifically supported because, as I mentioned before, cannabis at different THC levels, I think, has very different risk profiles. But unless and until we see some federal leadership here that's based in not just the science, but I don't call it the politics, I call it the populism of this drug, we're going to have innovation from the ground up, literally, people growing their own, people accessing this drug and becoming acclimated to this drug without an awareness of the harm profiles that are there, depending on which version of the drug and how it's packaged and what it's packaged with and what it's grown with. All the things that allow us to feel incredibly safe going into not just a drugstore, but literally a gas station and buying a Tylenol pack or whatever other drug we can buy there ought to be applied to every drug. And yet here in the cannabis space, it's been a lack of federal involvement, again, inconsistent as I read the Controlled Substances Act, that has gotten us to all the dangers and concerns that Dr. Madras is rightly identifying. We've got to get off this status quo because the people are saying in a variety of ways that it's not what they think is consistent with their own felt understanding. And of course, if the concern is polluting or otherwise harming the medical system, a whole bunch of marijuana advocates are like, yeah, just deschedule. There's your solution. Take it off, treat it like alcohol and tobacco. I'm not sure that's the right solution either, but I think to look at what's happened to date, identify all the problems with state level reform and say that's a reason to stick with what we've got at the federal level completely misunderstands the federal failures that got us to this point.
Yang, I want to leave time for some questions by the audience, but I do want to ask you a few questions at the outset. And let me bring two factors into question here. I'll try to mix them together and get your responses to them. One is that the Controlled Substances Act is not the only statute that's relevant here. The Food, Drug, and Cosmetic Act is also relevant. And for 80 years plus, we have trusted the Commissioner of Food and Drugs to make the decision what is a drug and whether it's safe and effective. And the FDA has never found that cannabis is safe and effective. And that's because of the second factor here. Cannabis is a plant, not a drug. Cannabis has a lot of cannabinoids in it, the psychoactive and biologically active compounds, and some of them might be very helpful. We already know some are, and the FDA has approved them, but the FDA hasn't approved, to my knowledge, a plant of any type as being a safe, effective, and uniformly made drug. So how do we deal with the fact that even if the Attorney General approves the rescheduling down from Schedule I to Schedule III, the Commissioner of Food and Drugs hasn't approved the use of cannabis as a new drug. And therefore, it is still going to be illegal when shipped in interstate commerce because you can't ship something in interstate commerce if he hasn't approved it. So either one of you can answer first, and I'll give the other one a chance to respond. So it's a fielder's choice to you guys.
Go ahead, Dr. Madras.
Well, I'm just looking at the some of the questions as well. Paul, what you addressed is there any evidence of a plant The problem with approving a plant is that it's not a plant. It's a heterogeneous array of every single type of strain, of different THC concentrations, of different types of concentrates, dabs and shatter, and every different type of route of administration. So that what is currently available in a dispensary is not only a widely divergent set of plants, but also different concentrations, different doses. And this is completely contrary to what FDA's drug approval process has maintained for the past 100 or plus or minus 10 years. And that is one of my major problems, because there's no dose regulation. And I think that Professor Berman hit on a very important point. You know, if we throw one designated thing called marijuana into Schedule 3, that includes everything, all these things, without known pharmacokinetics, pharmacodynamics, safety in terms of long-term use and so on. So number one is, I think that this is so contrary to our drug approval process that it absolutely makes no sense. The second point that was raised is that the people want it.
And let me just interrupt for a sec and let Doug respond to the point you just made.
Yeah, and I'll jump in. I largely agree, though I think it's important to not lose sight of the fact that the FDA has approved a handful of synthetic THC drugs that had to be synthetic because marijuana was illegal. They've also approved a CBD Epidiolex, which my understanding has been quite successful and quite important in advancing treatment for severe seizure syndromes. And in fact, it was only less than 10 years ago that the initial move by Congress in what was called the CARES Act was to try to move cannabis from Schedule 1 to Schedule 2, I believe, based in the particular concern about making parents with children with severe epilepsy syndrome, Dravet syndrome, have access to CBD applications, which were proving quite efficacious, though it took us, depressingly long to figure that out. And in a kind of sleight of hand, we ended up making CBD legal through the Farm Bill. That's anything but science. That, to me, is another layer of the federal government being motivated by a range of considerations other than public health and public health research and science. That doesn't mean we should say, well, all bets are off, let's deschedule and go crazy, but it does highlight the reality that, the experience, the history of law is not logic, it's experience. And the experience has shown us that as you move something to a schedule in which research is more available, private research money is more available, and that pharmaceutical companies have more of an incentive. I don't actually think they're going to have much of an incentive to research with the cannabis plant for the very reasons that Dr. Madras was highlighting, that it's a very complicated plant with all sorts of components and ingredients. And the problem is in the medical space, if people think, well, why should I go to a doctor, get a prescription, and try to get a certain controlled version of one chemical in the cannabis plant when I can go, down the block to a dispensary and just buy whatever weird named product I can, and that's cheaper and easier, and I don't need to worry about anybody knowing what I'm doing.
Professor Berman, can I ask then, is it an irony of the legalization efforts that we've seen in the states that they have effectively made it impossible as a matter of economics for pharmaceutical companies to do the types of research that would be necessary, because for the exact reason you've said?
My understanding, it's been the Schedule 1 status that's made it impossible, because the amount of work that goes behind being able to do research effectively for Schedule 1 drugs is so much greater. They could do it, but of course, it's not just, this is the important point. It wasn't that marijuana showed up only in 1996 when California started reform. Marijuana was the most widely used illicit drugs in the United States for literally decades upon decades. And so to the extent to which the pharmaceutical industry was worried about competitors, they were worried about an illicit market that was robustly providing this drug, and still is robustly providing this drugs to anyone, anyhow, at any time, day or night. They figured out Uber before Uber figured it out, because at the end of the day, that's the nature of the drug trade when it's illicit. You end up actually making your money on service rather than on the drug itself, which is undependable. And that's the world in which a legalized industry is fighting against. And that's both for the pharmaceutical and even the legalized businesses today are still fighting unsuccessfully against an illicit market.
Let
Well,
me go to a couple questions from the audience. Kelly Faglione asked the following. Is there a quote unquote lack of medical evidence because it, presumably cannabis, has not been widely or sufficiently studied, or because it has been well studied and the results fail to support a legitimate medical use? Professor Madras, let me put that to you.
well, it's very interesting, and it's also follow-up to what Professor Berman said. Cannabidiol was in Schedule 1. A pharmaceutical company decided there could be enough evidence. It had nothing to do with Charlotte's Web or any of the grassroots movements. They had shown far earlier than that cannabidiol could have some anti-seizure properties. And they decided to do all the necessary experiments to get it through the FDA approval process, and they did. And Epidiolex is a result of that. So Epidiolex was moved out of Schedule 1 into 5 as a result of a pharmaceutical company deciding to invest in it. Now, what about THC, which is also in marijuana? For many years, people said, well, we can't use it. We don't have the data on medicine because it's in Schedule 1. That's just baloney, because cannabidiol was in Schedule 1 and a pharmaceutical company did exactly the due diligence necessary to get it through the FDA. So why not do it with THC and marijuana? Many pharmaceutical companies spoke to me about this because I used to ask them why not, and they would say they didn't want the liability because THC in marijuana is psychoactive. It promotes dizziness, it promotes depersonalization, it promotes euphoria at the therapeutic dose, which it could be quite different, for example, than opioids.
Okay,
They didn't want to touch it.
Let me go off of what each of you just said, something about the testing for Schedule 1 drugs. And this question I'm going to put to Professor Berman. We have seen recently a fair amount of interest in reconsidering different psychedelic drugs for use in the treatment of either major depressive disorder or post-traumatic distress order. In fact, there was an application for MDMA to be approved for use in this regard. And from what I read, the staff had recommended against it. So it seems like people nowadays, at least, are able to find ways to do the research necessary, even if a drug is in Schedule 1. So, Professor Berman, is that a completely new development, or has it been like that for a long time? It's just that people were either worried about the liability or they were worried about not being able to make a profit. What do you think?
I think it's all of the above, right? First, indisputably the costs for doing the research studies, the ability to do it, access the product, all of that go up exponentially when you're talking about a Schedule 1 drug. In addition, especially if those drugs are available on the street, there is a profit margin concern because you not only need to develop the drug, but you're going to need to develop it in a way that allows you to compete with the illicit market, which is an awful lot to expect. And then on top of all of that, you have the stigma and challenge that comes from that, right? You know, there's a bunch of reasons why all those commercials we see on TV for all these weird drugs have weird names and we haven't heard of them before. Because if they were to simply say, this one's an opioid, this one's related to marijuana, that would create its own stigma and challenge in terms of drug marketing, in terms of drug sales. That doesn't mean it's impossible. Again, Epidiolex is a great example. It can get done, but at a much higher cost, at much bigger challenge. And I think this is the last part of it that, again, I return to the right to try law that was signed into law. It has a certain conception of risks and reward. If there's any risk, we're not going to pay it off. I think my understanding of the most recent literature about how the psychedelic studies are going, it didn't work out as well as they had hoped, and that the odds of getting FDA approval is slim. That's going to just depress innovation, depress concerns about this, because these are hard drugs to study, even if you didn't have the federal overlay of prohibition that makes it even harder. And so it's possible, and it has been our policy for 50 plus years. We say, sorry, we'll do without these drugs. We'll do without the possible benefits that they can provide because the risks are too great until there's a proven outcome like with Epidiolex. But again, whether it's psychedelics, but particularly when it comes to cannabis, we have generations saying we get some benefit from this, and we don't want to comply with that risk profile. That's debatable. Maybe we'll get to the populism of all of this, but I think that's an important component when the bureaucrats say, well, we don't think you can use this safely. And the people say, we think we can. I'm still kind of inclined to go with the people over the bureaucrats.
Okay, thank you. This question will be for Professor Madras. Dan Vietz essentially asks, given that cannabis seems to be safer than alcohol, tobacco, or even some over-the-counter medications, what is the common sense sort of argument why cannabis should be restricted when alcohol and tobacco have only an age restriction, essentially? If you're above a certain age, you can buy alcohol and you can buy cigarettes, even though cigarettes kill more people than alcohol or cannabis. And even though alcohol kills an ungodly number of people each year in alcohol-impaired driving accidents or crashes is a better term. Is there just a sort of common sense way of saying, no, cannabis is worse than those? Or is it just a matter of we can't get rid of those, so we shouldn't legalize cannabis to be an additional impairment?
I think the answer to that is that we are just presenting our society with another public health challenge, public health and safety challenge. There are a lot of people who use and claim they're fine, but that's not how the drug approval process works. If it did, Laetrile would be used by every person who has cancer, and it would probably kill them. Laetrile was approved by 17 different states by ballot initiatives because the patent holder wanted to make a profit on it and decided that it was a very effective chemotherapeutic agent until the FDA and Health and NIH got involved and sponsored clinical trials and showed that it is in fact not only ineffective, but it could be a poison. Because it has cyanide in it. I think the problem is that if we listen to people who feel good about drugs, and the same can be said for alcohol and tobacco, and marijuana makes people feel good. It makes them feel high. And therefore, it should be approved as a medicine. That makes absolutely no sense whatsoever, because sometimes one has to have an impartial and regulatory oversight that supersedes what people say makes them feel good. Sativex is another example of a drug. It's a hybrid of THC and cannabidiol that was approved in Europe, and then it was put into clinical trials in the US for pain, for cancer pain, because everybody was saying that marijuana is very effective for cancer pain. It was in marijuana extract. And after 2 phase 3 clinical trials, it failed absolutely in their primary endpoints in terms of alleviating pain. So you have to do the clinical studies instead of what makes people feel good. And I think that's really important. The final point I want to make about comparisons between drugs, alcohol and nicotine and marijuana is that death as an outcome is not the only criteria that one uses in terms of gauging whether or not a drug is safe or harmless for the public. Marijuana has a host of brain changes and brain effects that I think are extremely important to consider in deciding whether or not it's safe. Even if it doesn't kill at high doses, it could affect your brain in ways that essentially could become a lifelong sentence of some psychiatric condition. So I'm not willing to say that because alcohol can produce cancers and liver disease and all that, or death over time, that because of that, or because of nicotine causing lung cancer and cardiovascular disease, that it's worse or better. I think that we have to make our decisions based on a drug by drug basis.
And if I
Thank you.
could, if I
Go
could
right
jump in-
ahead. Go right
Yeah.
ahead, Professor Berman.
I just want to sort of, in some sense echo some of those points, but particularly lean into the issue of culture. Because I think one of the challenges and the question about sort of prohibition and some other questions I see in the Q&A about how do we kind of, have public perception be altered here. I think when we look at alcohol and tobacco particularly, culture is an incredibly powerful and important force. Law and conversations about legal reform certainly shape culture. But ultimately, right now, within a probably 5-minute walk of where I am on Ohio State University, I could get to a place to buy a lethal dose of alcohol, hard liquor, because we sell hard liquor in doses that could kill, right? One big jug of alcohol can kill a person in one sitting, yet that doesn't, or occasionally we have overdosing. We certainly on university campuses, have hazing and other things that lead to very sad and disconcerting overdose deaths from alcohol, but it's a real rarity. And it's not a real rarity because of our packaging laws or other things. It's our culture that does that. Another aspect of that culture, and I bring this up with my students all the time, is even though it's illegal for 18 to 20-year-olds to drink, they do it all the time on campus, but in a relatively safe place. Again, I mentioned hazing. It doesn't always work out safe, but there's a lot of attention that's given when there is really unsafe or at least deadly alcohol consumption. And I certainly wouldn't say that I learned in college the healthiest drinking habits, but that's another aspect of the way in which our legal drugs get acclimated to us as we're growing and developing. And especially Dr. Madras's point that the evidence is pretty conclusive, I think, at this point, that cannabis's impact on the developing brain is something we need to very much be worrying about. We may need to be thinking quite seriously about not just 21, but maybe 25, or ages that encourage people to use cannabis later in development so that it doesn't have the risk at the same level that also goes to THC levels that I mentioned earlier. And we'll know, even if you set the age at 25, that people are going to use cannabis as teenagers and as young adults, but you shift the culture. And that's something that I think we're not talking about enough when it comes to how our policies here unfold. It's not just defining the law sensibly and consistent with people's understanding and what the science supports, but it's also helping people understand that law can only do so much. And, that's itself the story of why our experiment with alcohol prohibition failed so miserably. And it's why I think at some fundamental level, why a longer experiment with cannabis prohibition has failed at this stage. Now, how we get to a better place, I think, is going to be turning on an awful lot of factors: science, law, important, culture, I think too often overlooked.
All right, let me ask a question then that stems from what you both just said. We're to the extent public health is a legitimate factor, and in this instance, I think it certainly is. What is the proper role of the federal government in protecting public health? I've always thought that the nation had committed itself to letting the FDA make these sorts of decisions. But we've heard nothing from the FDA commissioner. We heard it from an assistant secretary for health at the Department of Health and Human Services. The FDA commissioner has said nothing. The DEA administrator has said nothing. Now, maybe they're saying nothing because they're being good soldiers and they don't want to upset what, the president decides he wants to do. Fine. But if we're really talking about public health, what is the proper role of the federal government? And shouldn't we be listening more to the Food and Drug Administration and the Commissioner of Food and Drugs than to the Attorney General? Bertha, you go first and then Doug.
Well, of course, the FDA is the final arbiter in terms of what drugs are approved for medical use. And at this point, the FDA has, as you said, has not said anything about it. In the past, it did. The Surgeon General did. They were all against it. In fact, when I testified against,
And if I may interrupt, I think it was in both administrations, both Republican and Democratic
Yes.
administrations.
Yes.
Neither the FDA nor the Surgeon General came out in favor of approving cannabis as
Yes.
a drug.
And what has happened since that rescheduling controversy in the Eastern District of California is that the data on the adverse effects of marijuana have gotten worse and worse and worse. And the FDA, in fact, they were instrumental in partnering with the Department of Justice in opposing the rescheduling. The data has not gotten better in terms of marijuana as a medicine, or marijuana as a safe drug, or marijuana as a recreational drug. All we have now is what the public opinion is about the drug. It is at this point, from the official drug approval process, there isn't one indication that would pass muster by the FDA.
Professor Berman?
So I'm all for having the FDA play a more active role in this space. They've not had a recent history that is inspiring. I'll focus particularly on, again, what happened as a product of the Farm Bill exempting CBD products from being considered part of marijuana. The FDA spent the better part of 2 or 3 years taking comment, studying how it was going to deal with CBD products, and then at the end threw its hand up and said, Congress, give us the tools to do this. We can't figure this out on our own. And currently we have CBD products of all sorts. We have intoxicating hemp, as it's sometimes called, Delta-8 products flooding the market. And the FDA is, I don't want to say asleep at the switch as much as this is something that a commercialized industry has taken and run with, and done so without any reason to worry about federal oversight, because the feds have largely said, we'll keep our eyes closed, we'll defund DOJ to look at medical applications, we'll have memos that will say we're not going to enforce, and the FDA is largely hamstrung in an ability to do much about that. I'm hoping the rescheduling from Schedule 1 to Schedule 3 will be the start of a change of attitude away from not our problem to we need to take a leadership role to gather evidence, to gather data, so that not only can the FDA and other federal agencies play a more active role in regulatory and policy work in this space to help the states that are themselves sort of catching up to the people, but so that we can even understand what's going on. It's so hard to collect data in this space for a variety of reasons, including that at a university like mine, we can't touch the plant. It's still Schedule 1. I can't walk into a dispensary. I can't walk into a dispensary as a legal researcher and purchase the product in the hope that I can understand how they're packaging it, how they're selling it. I'm violating federal law, and I'm tenured, so I don't worry too much about driving by and checking out what the dispensaries look like. I actually know a number of lawyers who work on behalf of dispensaries and help with the regulatory efforts at the state level. But the extent to which there is this barrier to even understanding what's going on is driven by the status quo should not be overlooked. And to expect FDA to do a lot more without passing some of the bills, there are bills in Congress. I believe its own, one of my representatives here in Ohio, he's not mine specifically, Dave Joyce, has a bill called the Prepare Act that's designed to try to get the federal government to at least collect data on these issues. And that's gone nowhere. And so
All right, well, let me interrupt then if I can. We only have about 3 to 4 minutes left, and I would like to give each of you the chance to sum up. And Professor Berman, I'll let you go first. Maybe the summing up will be exactly what you were saying, that what we need to do is get Congress more involved to look at this and pass legislation. But I'm not going to put words in your mouth. I'm going to let you go first, and I'm going to let Bertha go, but I'm going to be pretty tough, just 2 minutes for each.
I will theme it this way, which is, I still believe we live in the greatest democracy that this world has ever known. And one aspect of that has been a direct democracy process at the state level where the people have voted consistently, repeatedly, over and over and over again that they want there to be medical applications of marijuana available, and then they also want to have access to recreational marijuana. The only reason that pattern has continued without even pause, except for 1 or 2 states, and even there's 40 to almost 50% support, is because the people's experience with this drug is generally positive or at least benign. And the extent to which the federal government has not cued into that yet at any level is why we're behind the 8 ball on a bunch of public health issues. It's also driven by what we haven't talked about as much as we should, that the people have seen the severe and racially disparate criminal justice footprint here that needs to be addressed. And the only thing that has addressed it, despite advocacy of all sorts for many, many years, has been legalization. That's prompted pardons. That's prompted expungements. That's prompted a pulling back of the ugly footprint of cannabis prohibition. And so the people are continuing to applaud that. And if we don't get with the people, we will disserve the people.
Professor Madras?
Thank you very much for that summation. I entirely disagree with you for the following reasons. That every single movement to legalize, to medicalize marijuana was driven by huge investments and strategies by a very small number of people. There wasn't a grassroots movement among the medical community to make this into a medicine because they heard from patients that patients are doing so much better on it. There wasn't a grassroots movement among parents, among teenagers that said, we've got to legalize marijuana because it makes you feel good and it's completely safe and effective. Those talking points, safe, effective as a medicine, non-addictive, and so on, came from a campaign in which hundreds of millions of dollars were spent to convince the American public that this is a void in their lives that has to be filled by legalizing and circumventing the FDA. And that is a problem because the FDA now is going to be eroded in terms of its rigorous standards. The medical profession is going to be eroded because patients will say it is now Schedule 3 and therefore you have to prescribe it to me. The insurance companies may have to reimburse without any medical evidence for almost every single indication. We are going to have a complete social upheaval thanks to a movement that began because of a few interested billionaires spending hundreds of millions of dollars to convince the American public that this is better than alcohol. And it isn't better than alcohol because it does have detrimental effects on the human mind, which is the repository of our humanity.
Well, gang, we're going to have to leave it there. I want to thank my 2 co-participants, Professor Douglas Berman, Professor Bertha Madras. They are experts in this subject, and they are great to listen to. When they agree or disagree, it doesn't matter. Everything they say is worth listening to. I want to thank the Federalist Society for allowing us to have this debate. And with that, let me turn it back over to FedSoc. I'm honored to have been the moderator.
Thank you so much. I'll echo the thanks to our panelists. Really appreciate you all joining us, lending this part of your days for the lively discussion. It was interesting to listen, so really appreciate you spending the time. Thanks also to our audience for joining and participating. We welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.